thank you for tuning in today to attend our new episode of the Digital First Education Series. We are glad to welcome you all for all this exciting session. My name is Bérangère Ferrier. I'm part of the French cluster. We are a group of French experts based in LA and Chicago, and we help French-speaking people in the US to reach their business goals. We offer mentoring opportunities, an extensive network, and a deep knowledge of the different ecosystems in your region. Today, we will speak about legal for web and which basics and regulations we should know about when we have a website. Do not hesitate to ask your question in the chat. We'll take a few minutes at the end to answer some of them. But first, let's present our speaker, Alpha Béchir. Alpha, good morning.
Good morning.
So Alpha is an attorney at Adley Law Group, specialized in intellectual property and media, privacy and cybersecurity, digital media, and entertainment. She's an active board member in Paris and in California, and she's part of numerous organizations promoting diversity and women empowerment in society. Alpha, you can begin your presentation. Welcome again.
Thank you. Thank you, Bérangère. Thank you, French Cluster, for welcoming me and inviting me to speak on this very hot topic. So I'm going to start. So like Bérangère say, I'm an attorney specialized in intellectual property. I practice both in Paris and since 2015 in Los Angeles, California, and I have a bar in both California and Paris, which for this topic we are going to discuss is really helpful because it's very international and cross-border. So it's definitely something that's been helpful in my career in terms of enforcing and practicing privacy law. So the way I will present this today, obviously, it's going to be a very superficial analysis, a general perspective of privacy, of data privacy, and the thing you should be mindful of while collecting data, while doing business, while having your website, etc. The things it's important to keep in mind. This is what I'm going to touch upon today. But I invite you to reach out if you have more questions, if you want more personalized answer, because again, it's going to be very general, and from a company or client to another is extremely different. So I invite you to do not hesitate to reach out if you have any question to me or to Bérangère. So I'm going to start discussing a little bit the origin of personal information, data protection. Then I am going to explain why it's important right now, and then more in the way discuss who it applies to, so you can know if it's something that applies to you, and how do you comply, and finally, what are the risks for clients, company. So the origin, as for many other rights, affecting consumers and users and people, individuals, it comes from Europe. In the early 70s, Germany started discussing the concept of protecting privacy rights of users. It's something that's in most countries, in every constitution, every human rights act, because it's simply, as the name indicates, rights is just applied in the digital world, the web world, and the modern world. It's not the protection of your image right, of your name now, it's your data. So Germany started discussing that in the early 70s, noting the evolution of computers. And Sweden in 1973 was the first country to adopt a national privacy law. Fast forwarding to later, in 2018, Europe adopted the GDPR, which is the General Data Protection Regulation in 2016, sorry. And to this day, it's still the most important and the most influential act that has been adopted in the world. Many countries take inspiration from this act because it is well done, very important, and the best law existing in this area. So moving to the US now, in 2018, first it was there were some fragmented regulation here and there. It was by sector, by industry. For example, there were something to protect the privacy of children. There were some law that apply to the health industry. And finally, the same way Europe is very often ahead of its time to protect human rights, in America, California is. So California introduced a first regulation in 2018, which is the California Consumer Privacy Act, also known as the CCPA, which has been adopted, the drafting started in 2018. It was adopted later, modified several times, and finally entered into law with the Attorney General that sanction and regulate on January 1st, 2020. So now it's fully, my dog, sorry. It's so now it's fully applicable in California and beyond. Following this California Consumer Privacy, California Consumer, sorry,
CPA?
Yeah, the CCPA. I'm disturbed by my dog barking. Following this, last year in November, California voters adopted a new regulation, a new privacy regulation that simply increase the rights in the CCPA and makes California regulation closer to the European GDPR. And also what's interesting is it's going to create its own institution that's going to be dedicated to controlling to control data regulation, cybersecurity, etc.
Oh, like the CNIL in France?
Exactly, yes,
Okay.
because right now it's the Attorney General. Everything is under the Office of the Attorney General, and now there's gonna be its own institution in charge of regulating data collection, data privacy, etc. So also beyond California, it's very important because although it is the first and the most inclusive act that have been adopted in the US, and although it's only California, it's actually very broad and it's very significant because this is the beginning of the US being every state a lot of states are preparing their own privacy act as we're talking. Washington is, New York is, Maine has done, Nevada is preparing as well. So really every state is looking into it and preparing something. That's not something that can be overlooked at this point. And the reason why it's important is also to know that there is a federal regulation that is about to be adopted as well. So it's in discussion. It might happen this year, it might happen next year, but very soon it's going to be a federal regulation that applies to all America. And it's important because as of now, you might be thinking, which is kind of true, that if you are an international company doing business in Nevada or in California, which one applies to you? Do you need to comply with the Nevada law or with the California law, with the New York law if your business reach consumer theirs? So the federal regulation is going to fix this issue and unify the American effort toward more privacy security, which is again important because the bigger picture and the goal every country in the world is trying to reach at the moment is a internationally unified laws that protects you wherever you are, where um, whoever you're doing business with, wherever they are, if they are in Japan, China, America, France, you kind of have the same right, and the same protection to your right is guaranteed as a consumer. So why does it matter to have some awareness of what's going on and knowledge and take action as a business? It matters because, again, it is an international effort. It is something that the goal of those regulations is really to make consumers and businesses think about data privacy and data collection as an automatism. The same way people use so often freedom of speech, they want the privacy rules and privacy and data collection to be a second nature for business and consumers, because really it is of significant importance. To give you an example, yesterday Grindr has been sanctioned 11.6 billion, if I remember well, in Europe for leaking the data they've collected from the user. And it can have a very heavy heavy consequences. If you think about, for example, in this case, Grindr leaking data of their consumer, it's a gay dating app. So information about this, for example, can go. They were leaking them in other platforms in this case, and there were no guarantee that those leaking were staying in the country. So this type of leaking can go to Afghanistan, can go to Iraq, and it was discussed in the case. The courts judge the fact that if it goes to Iraq, Afghanistan, this type of country does not guarantee the rights of homosexual people. So potentially their life is in danger. So this is an extreme case, but to give you an idea of how far it can go and how important are the protection of personal information. The other thing, in a more business, with the more business mindset, is the fact that the goal, by adopting all those regulations back to back and constantly talking about that and changing, modifying the regulation, the goal for business is to adopt, again, an automatism of checking the data privacy, the data collection. They want business to regularly, once every 12 months at least, review, update their privacy policy. First, to make sure that it's still compliant with the regulation that keep moving as technology advances, as virtual reality, etc. It keeps evolving. So as the law evolves, you have to make sure that, one, you're still complying with the law, and two, that the way you describe your activity is still accurate, that you're not collecting more or less data that you displayed on your website, that you're not doing something else that you have described to your consumers. So this is why they suggest to check and update your privacy policies at least once every 12 months.
Okay.
So let's get into a more practical discussion. Does it apply to you? Does the California regulation specifically apply to you? The short answer is yes, most likely, because it's very, very broad the way it's defined in the regulation, in the CCPA. But to be more precise, the conditions are: if you are a for-profit business, if you collect California consumer personal information, you do business in the state of California, and then there is some financial condition, and then you meet one of the following criteria, which is you have at least 25 million in annual gross revenue, or you buy, sell, share, or receive the personal information of at least 50,000 California consumer, household, or device, or you derive at least 50% of your annual revenue from selling California consumer personal information. in brief, most companies doing business in California are included in this definition. It is very, very broad, and contrary to what we would think, it does not only concerns online business. If you are a store, you are a florist, and when your consumer client come and buy flowers, you let them file a little form with your name, your information, etc. You are collecting data. So technically, you are under the umbrella of the CCPA. Yeah, so most likely, if you collect any type of data, any type of information about the consumers, whether you are sharing them or not, whether you are selling them or not, you most likely are under the obligation to comply with the CCPA. And I think it's very important to repeat because, for example, one of my clients that only lately, a case I've worked on, one of my clients that only work with business, and only in a very small portion of the activity consists on having interaction with consumer online users. So they have their website, but they really work with business. They don't work with people going online and doing things online. So, and they, under this, based on their activity, they really believe that the CCPA was not necessarily applying to them, or that they didn't need to provide this extended information online about the way they're collecting data about the user, because they, oh, if someone just come and put maybe their name or any type of information, for example, travel agency, their dates of traveling, for example, most likely it's enough for you to have to implement a privacy policy and inform people about their rights and their and the way you're collecting and what you're collecting, etc. So so yeah, the way you comply with the CCPA and also with the GDPR, the three key words really are transparency, clarity, and trust. So this is the goals of all those regulations. This is what they're trying to reach for every business, every company collecting, processing data, is to be fully transparent about their activity, about what is collected, when it is collected, why, who it is shared with, what the user has to do to get information about the data that have been collected, how to access them, how to erase them even. All of that has to be explained very precisely, very clearly to the consumer, because again, the way it's seen is it has something that is easy to understand for any user, any online user that goes online. They have to be able to understand. I know that in practice, in reality, most of the time we just click accept and we see and we change the page and we do what we have to do on the site we're on. But the reality is that this has to be extremely detailed, extremely transparent, extremely clear for anyone to understand, and yeah, to understand, comprehend, and apply. So yes, this is the three keyword, and you have to be very precise again about what you collect, how you collect it, etc. And the way it has to be done is very different from a company to. If you are only doing business to business, is different that you dealing directly with consumer. Also, several of my clients are what we call data processor, which means they don't interact directly with the clients and collect their data for a goal that is displayed to this person. What they do is, well, I have specifically a client in mind that is in the business of digital media advertising. So the activity consists of not working with consumer users, or maybe 10% of it on the website to display their brand, but really they work with apps. And with these apps, the apps provide data to my client, the advertising company. And this company specializes in processing this data and generating advertising for this user of the app. So there's no contact between the users and my clients, the advertising company, no contact at all. Yet they have the information, they process the information, they use the information as the major part of their business activity. So for this type of business, which are more and more important in terms of in revenue everywhere in the world, this type of business focusing on data collection, data processing is becoming more and more important internationally. For this type of business, obviously, it's very different. What is asked from you from the law is very different than the florist or someone who has their website and just display their brand, and you can contact them and have access to their services or their goods. So it's very different. So it's really hard to do a general, but in big lines, this what it asks from you is, again, to be transparent, clear, and trustworthy. But also, in certain cases, companies will have to implement certain mechanisms, such as a special toll number dedicated to treating data demands, because what comes with all those privacy laws is the rights of the consumer, of the user, to access the data you've collected, to ask questions, to tell you, I want you to delete this about me. I will also want to know when you are automatically deleting my data. So all this thing, again, transparency has to be very, very precise. And the goal is for the user, the consumers to have access, understand, and trigger those rights. So in certain cases, you have to implement mechanisms such as toll numbers, such as a web form dedicated to treating those requests from the consumers, and or a web page dedicated to that. It can be the law gives different options for you to choose of, but yeah, which also highlight the fact that in certain situations, business will have to invest more than just having a privacy policy put online. They will have to invest in, for example, forming their employee into knowing the basis of privacy data and how to treat personal information of the users. They will have to implement in their handbook, for example, information about how the company treats privacy, personal information, collects, etc. So it will be more and more a day-to-day thing. And this, again, this is what the regulation wants. They want you to make it an automatism to think privacy, data collection, to think of it as a human right, as a capital right that needs to be protected at all time, not at some point. It has to be an automatism. So the sanction, why it's important also in terms of sanction now, in California, the Attorney General is regulating this area. So they started sanctioning and enforcing the CCPA on January 1st, 2020. So it's pretty recent. And lawyers and people in this sector still are analyzing how it's going to take form exactly, because we still have few examples of enforcement from the Attorney General. So the Attorney General will enforce. First thing the office will do is go online, check when was last updated your privacy policy, and mostly it's 2019, and I'm going to say if it's before 2020, most likely you are not compliant. And this is a really easy way for them to check, like, okay, when was the privacy policy updated? Too late. There is no way this can be compliant, and most likely it's not. So this is the first thing. And the sanctions are, first, they will send you a notification to ask you to comply, and you will have 30 days to comply. So this is the good thing. You get a notification before they start the action. But the penalty can range from $2,500 to $2,500 for non-intentional violation to $7,500 for an intentional violation. And this is, again, per violation. it could easily reach 100,000 violation or more in a few months or year. It's very easily done, depending on the size of your company, of course. And more importantly, class actions are open, which means that a user can go online and get a violation of their in some way of their personal information, and maybe as a user, a single user, they cannot do much, but class actions are open, so it can very easily and quickly turn into 5, 10, 15, 100, 10,000 users if you are that successful, and this is the goal. So you don't want to get to thousand and thousand and thousand of user reporting that you have breached their that you have leaked their personal information, which could result in a million, even billion sanction against your company. So
yeah, we've seen some examples in France recently, and yeah, it's been painful.
yes, yes, it is. Well, I mean, it's always important to be proactive about this type of thing, because really
Yeah.
the amount you put in implementing this type of rules is always good investments, and you actually it avoids being sanctioned at least 3 times more, which is generally the case.
Yeah.
So this is all I wanted to discuss. I guess in conclusion,
Yeah.
what I think is important to remind businesses collecting data is the fact that really what is expected from you right now is to make it a second nature. And this is the reason why all those regulations are being drafted everywhere, are implemented everywhere. Brazil is has one, India has one, China is, believe it or not, China is preparing one right now. I say believe it or not because they have a history in terms of intellectual property and privacy of not being very protective of this type of rights, but they are preparing, and it is inspired by the CCPA. So the reason why is this is going to be international, and it's going to be, ultimately the goal is for this to be implemented equally everywhere, and company will have to comply with this uniform regulation laws. And every regulation that has been adopted in general, the CCPA did that, the GDPR in Europe did that. They gave companies 2 years, a 2-year heads up to comply. The CCPA, that they informed company that it was about to be adopted, that the sanction, the Attorney General was to enforce, and company had literally, in 2018, I started working with company to start implement this thing. And although it was just a draft, the regulation was a draft, it was still modified later, they were still expecting companies to do their best, to at least do their best to try to comply, and it needs to be shown on the website. Again, going online, seeing when was last updated the privacy policy is enough for them to know whether you even tried or not. So for all business out there, every person collecting data, try to really make it a second nature. It's not something that can be overlooked anymore, and it's only going to be this fact is only going to be more and more true as the months pass and the year pass, especially under COVID. And yeah, so be mindful of that and try to comply with the privacy law as much as you can.
Now, thank you, Alpha. I guess we can have some question, related to what you said. You talk about all these regulations and the way that we have to be compliant with the law. So do you think that we can use some, website to generate this kind of documents, or is it better maybe to work with an attorney? But what are the conditions? I mean, can you help us with that?
Yeah, well, it became over the years of a very common question in different area of law, whether it's corporate to form your company or to register your trademark, and now or generate a privacy policy or term and conditions. Well, my answer to that is that I would not recommend it as you expect, because I'm a lawyer. And as a lawyer, I would give you the most protective answer and the safest answer, which is every company is very different. And again, this regulation requires from you to be very transparent, very clear, and very specific about your activity, about what you're doing with this personal information. Why are you collecting them? Are you sharing them with any third party? Um, um, what exactly are you collecting? Is it just bank credit card information? Is it also the address of the user? Is it more than that? Job, etc. They want you to be very, very specific about what you're doing, and it needs to be very clear looking at your privacy policy. And quite honestly, it's very clear looking at a privacy policy whether it has been automatically generated or not. And I think it's very important to choose a very personalized and adapted solution, and to work with someone that will analyze your business and draft a privacy policy. But it's not just drafting a privacy policy. As I said, there is certain mechanism that need to be implemented. So this person that knows, analyze your company can also, and it's recommended, work, for example, with your employee or with your company to make sure that every mechanism is there, that the toll number is there, that the web page dedicated is there and has the proper elements. Short answer, it is very important to work with an attorney that would analyze your business and draft something that is adapted to your business.
Yeah, definitely. And also, someone is wondering if the company is doing business in both Europe and United States, which regulations should we comply with?
It's a very good question, very important question. And as someone who works regularly with international company, I deal with that a lot. So basically, again, the goal is for this law to be international and apply uniformly. It's not the case now. It will soon, but it's not the case now. So now the short answer is all of them. Okay. So if you are in business in Europe or in Japan or in China or anywhere, and you are reaching out to California consumers, for example, or European consumers, you will have to comply with the GDPR in Europe, with most likely the law of your country, but also with the CCPA. If any resident of California can access your website, you can collect their data, put credit card information, even if you are wherever you are as a company, you will have to comply with the CCPA. So the thing that helps is the fact that every regulation has the same basis. When I keep like CCPA is inspired from the GDPR, the European one. They're all kind of inspired by the European regulation, and now they're just copying each other and just really securing the same rights and trying to make an effort in unifying. But as it is not yet, the short answer is if you reach consumers in a certain area, you will have to comply with their law. The way it's in law in America in general, not just for privacy, but for everything, is if by your activity you abide your business into the law of the country, you cannot pretend that you do not know the law of this country. So the rules of the country or all the states in America will apply to you, even if you are in France. And it's the same thing in the other way. If your business is in America and you're doing business in Europe, well, Europe is protecting their residents and their consumers, so you will have to comply with their law. And another point about California is not just American people and Californian, is California residents. Anyone that lives in California, regardless of their citizenship, can start an action against a company that has leaked their personal information. So yeah.
Okay, so okay, it's very key, and we have to be careful with every area of the world we are dealing with, actually.
Exactly. In a very practical way, example, when I work with European company doing business in the US, it is sometimes I review a privacy policy that is already European compliant. Sometimes it's not. So the ideal when a company is located in Europe is to work with European attorney to coordinate and to make sure that the policies or the contract, because privacy is not just the privacy policy. There are certain type of contract. There's there is cookie notice. There is all type of legal documents that are connected to privacy. It's not just the privacy policy.
I was about, sorry to interrupt, but to make a difference between the website that is just here to display what your service is and the website that is a marketplace and where you collect a lot of data about your consumer. So I guess both have to be careful with the privacy, but maybe the website just displaying your services and not interacting with the consumer and just for a B2B, business to business activity is less concerned. I mean,
Absolutely.
The marketplace and all this kind of website where you collect a lot of data. So
absolutely.
I mean, the conclusion, as you say, is maybe, as you said, is maybe each case, each company is different and has specific needs. And the best maybe is to discuss with someone to be sure that we are not missing something. And maybe we don't need the big, policy document if we are just a website, doing business to business. Or if we're a marketplace, then we need maybe to implement something very more serious and more compliant.
Yes,
and
absolutely. That is absolutely true. Whether you are Instagram, Twitter, any social media platform that's collect a lot of data, or like my client, that digital advertising company that focuses on really generate their business through processing those data with people they don't have direct interaction with. Or if you are only interacting with business, which by the way, you might collect information about business as well. Persons with regard to the law is not only individuals. If you collect information about a business is a person with regards to the law. So this is another thing. You have to put on notice the business you're doing business with of what you're collecting about them as well, just as much as an online user going online. So yeah, it's very true. Whether you are a social media advertising company or just really a website displaying your brand, it's very, very, very different what you have to do and how you have to implement those rules.
Yeah. But thank you, Olfa. It was very interesting and
thank you, Bérangère.
Important to know about it. So I think we don't have any more questions and this episode is done. Thank you again to you, to all our audience. And we'll post this content soon on the French Cluster YouTube channel. Do not hesitate to like and share. And we are happy if this episode has been useful to you. So take care, goodbye, and see you soon. Bye-bye, Olfa.
Bye-bye. Thank you.
Bye-bye.